1995. Across 6 states, death row rosters list fewer than 60 women. Of those, 7 are black, less than 2% of the national condemned population. The Department of Corrections updates its database every quarter. Families check online portals. Attorneys file motions in manila folders stamped with case numbers that span decades. Statutes promised finality, conviction, appeal, execution. The docket tells another story: remands, resentencing hearings, clemency petitions stacked in governor's offices, courtrooms in Texas, Louisiana, Georgia, North Carolina. Each jurisdiction follows different aggravator lists, mitigation standards, and appellate timelines. One woman's sentence was commuted after 23 years. 6 remain under active death sentences, their appeals advancing through state supreme courts and federal habeas proceedings. Victims' names appear first in every court order, as they must. Then, the procedural history. Thousands of pages, decades of litigation. This is their legal journey. These are the 7. Death Penalty Information Center, Annual Report 2000. Documents national statistics on women under death sentences, broken down by race and state. 1999 closes with 51 women on death row nationwide. 14 states maintain active female death row populations. 7 of those women are black, scattered across facilities from Texas to North Carolina. The disproportion is stark. Black women represent 13% of the female population, but occupy less than 2% of death sentences nationally. Texas leads with 3. Louisiana holds 1. Georgia, 1. North Carolina, 2. Each state follows distinct capital statutes. Texas uses multiple aggravators including murder during robbery or kidnapping. Louisiana emphasizes killing of law enforcement. Georgia applies malice murder with statutory aggravators. North Carolina weighs premeditation and prior violent felonies. Execution protocols vary. Texas uses a single drug injection. Other states maintain 3 drug sequences. Appellate timelines differ sharply. Texas averages 11 years from sentence to execution. North Carolina averages over 20. Families of victims wait, so do defense attorneys. Clemency boards meet quarterly in some states, annually in others. The docket moves slowly. Finality remains theoretical. The first name on the current roster, Carlette Parker, North Carolina. Sentenced 1998. North Carolina Department of Public Safety Offender Profile, Parker, Carlette. Online status page, listing conviction date, sentence, and current facility assignment. Carlette Parker enters death row at the North Carolina Correctional Institution for Women in Raleigh on April 17, 1998. Her case file runs to 4,000 pages. The crime, murder of her former boyfriend in 1997. Prosecutors allege premeditation based on witness statements and recovered text messages. Defense attorneys argue extreme emotional disturbance. The trial lasts 9 days. Jurors deliberate for 6 hours. They return a guilty verdict with a capital sentencing recommendation. The judge imposes death. Parker's direct appeal raises ineffective assistance claims. Her trial counsel failed to present documented mental health evidence, childhood trauma, diagnosed bipolar disorder, prior suicide attempts. Appellate counsel files a 300-page brief in 2001. The North Carolina Supreme Court affirms in 2003. State post-conviction proceedings begin. Parker's habeas attorneys locate a psychiatric expert who reviews medical records never introduced at trial. The expert concludes Parker suffered acute dissociative episodes linked to untreated bipolar disorder. Federal habeas remains pending. 27 years pass. The status page updates quarterly. Parker remains at the women's facility. Her clemency petition sits unfiled. Victims' families attend annual memorial services. They speak publicly, requesting finality. Blanche Taylor Moore, trial transcript, North Carolina vs. Moore, 1990. Testimony from forensic toxicologists regarding arsenic levels detected in multiple victims. Blanche Taylor Moore's case occupies a different forensic terrain. Sentenced in 1990, she faces allegations of poisoning her boyfriend with arsenic over several months. Prosecutors present lab results showing toxic concentrations in tissue samples. Defense attorneys challenge chain of custody documentation and testing protocols. The trial spans 6 weeks. Expert witnesses dominate. Prosecution toxicologists testify that arsenic levels exceeded lethal thresholds. Defense experts question contamination risks and lab procedures. The jury hears testimony about Moore's background. A grandmother, active in her church, no prior criminal record. Aggravators include premeditation and heinous conduct. Mitigation evidence includes Moore's age, 56 at sentencing, and lack of violent history. The jury recommends death. The judge concurs. Moore's appeals emphasize forensic disputes. Her attorneys argue that arsenic exposure could have occurred through environmental sources. Appellate courts reject these claims, affirming that multiple victims and consistent tissue findings establish intent. State post-conviction filings in 2005 raise new scientific questions about arsenic metabolism. The North Carolina Supreme Court denies relief. Federal habeas proceedings continue. Moore remains on death row. Her case illustrates how forensic evidence, when voluminous and technical, can anchor a capital sentence for decades. The legal question persists. Can trace element science alone prove premeditated murder beyond reasonable doubt? Families await resolution. So do appellate courts. Texas Department of Criminal Justice Death Row Roster 2005 official list showing Erica Shepard among 47 condemned individuals at Mountain View Unit. Erica Shepard's name appears on the Texas roster in 1995 following her conviction for the murder of a woman during a robbery in Houston. She is 19 years old at sentencing. Prosecutors present a straightforward capital murder case, felony murder with robbery as the underlying aggravator. Shepard's trial lasts 1 week. The jury hears testimony about the crime scene, forensic evidence linking Shepard to the victim's apartment, and witness statements. Defense counsel presents mitigation, Shepard's youth, troubled childhood, exposure to domestic violence. The jury deliberates and returns a death sentence. Direct appeal affirms. State habeas proceedings raise claims of ineffective assistance. Shepard's post-conviction attorneys argue trial counsel failed to investigate Shepard's history adequately. They present affidavits from family members describing severe childhood abuse and untreated trauma symptoms. In 2019, a Texas trial court recommends resentencing based on these mitigation findings. The Texas Court of Criminal Appeals reviews the recommendation. In 2021, the court rejects it, holding that the new evidence would not have changed the jury's decision. Federal habeas remains active. Shepard's attorneys file supplemental briefs emphasizing recent Supreme Court precedents on youth sentencing and trauma mitigation. The case continues. Shepard remains at Mountain View Unit. Her case demonstrates how mitigation evidence, even when documented and compelling, may not overcome appellate deference to original jury findings. The victim's family has attended every hearing. They request closure. British Foreign Office Diplomatic Note, 2007, formal communication to U.S. State Department requesting consular review of Linda Carty's case. Linda Carty's case carries international dimensions. Born in St. Kitts, she holds both British and U.S. citizenship. Convicted in Texas in 2002 for kidnapping resulting in death, Carty maintains she was framed by co-defendants. The crime, the abduction and murder of a young mother in Houston. Prosecutors allege Carty masterminded the kidnapping to steal the victim's newborn infant. 3 male accomplices testify against Carty in exchange for plea agreements, reducing their sentences to life. Carty's trial attorney, court-appointed and later subject to bar discipline in unrelated cases, presents minimal defense. No independent forensic expert is hired. Key witnesses go unchallenged. The jury deliberates briefly and imposes death. Appellate review reveals significant concerns. Co-defendant's testimony contains inconsistencies. Physical evidence does not place Carty at the crime scene. No forensic link, DNA, fingerprints, fibers, connects her to the victim. The British government intervenes. Diplomatic notes cite violations of consular notification under the Vienna Convention. Human rights organizations file amicus briefs. Carty's federal habeas attorneys argue ineffective assistance and unreliable witness testimony. Federal courts deny relief, holding that even if consular violations occurred, Carty has not shown prejudice, that earlier notification would have changed the trial outcome. Carty remains on death row. Her case is frequently cited in debates over consular rights and the reliability of accomplice testimony. International advocacy continues. Texas clemency procedures remain restrictive. The Board of Pardons and Paroles has granted clemency in fewer than 1% of capital cases since 2000. Victims' advocates emphasize the young mother's memory. They attend clemency hearings when scheduled. Georgia Supreme Court opinion, Moss v. State 2010, ruling affirming Tiffany Moss's death sentence and addressing unusual procedural issues arising from self-representation. Tiffany Moss's case stands out for procedural reasons. Sentenced to death in Georgia in 2019 for the murder of her stepdaughter, Moss chose to represent herself at trial. The judge conducted extensive competency hearings. Moss was found competent to waive counsel. The trial proceeds without defense counsel. Moss presents no opening statement, calls no witnesses, offers no closing argument. Prosecutors present evidence of prolonged abuse culminating in the child's death. The jury convicts and recommends death. Georgia law requires automatic direct appeal in capital cases. Appellate counsel is appointed. They raise claims of ineffective assistance, not of trial counsel, but arguing that the trial court erred in allowing self-representation under these circumstances. The Georgia Supreme Court affirms in 2021. The court holds that Moss knowingly and intelligently waived her right to counsel. Her decision, while unwise, was constitutionally valid. Moss's case raises broader questions. When a defendant refuses to present mitigation evidence, does the state have an obligation to do so? Georgia courts answer no. The defendant controls the defense strategy. Mental health advocates argue Moss's refusal to defend herself evidences untreated mental illness. Psychiatric evaluations conducted post-trial identify major depressive disorder and trauma-related symptoms. Federal habeas attorneys will argue these findings demonstrate incompetence to waive counsel. Moss remains on death row at Arendelle State Prison. Her case illustrates the collision between autonomy rights and systemic safeguards. If a defendant insists on self-destruction, must courts intervene? The victim's family has stated publicly that they believe justice was served. They also express concern about prolonged appeals. Georgia has not executed a woman since 1945. Moss's sentence, if carried out, would break that precedent. Protocol reviews continue. Louisiana Supreme Court docket entry, State v. Frank 2015. Order denying state post-conviction relief and detailing procedural history spanning 2 decades. Antoinette Frank's case is perhaps the most widely known on this list. A former New Orleans police officer, she was convicted in 1995 of murdering her partner officer and 2 others during a restaurant robbery. The crime shocked the city. A police officer betraying her oath, 3 victims. Clear evidence of premeditation. Frank's trial lasts 3 weeks. Prosecutors present overwhelming evidence, surveillance footage, ballistics, witness testimony. Frank takes the stand and denies involvement. The jury does not believe her. She receives 3 death sentences. Appeals focus on mental health mitigation. Frank's post-conviction attorneys present evidence of childhood trauma, diagnosed anxiety disorder, and stressors related to policing. Psychiatric experts testify that Frank suffered acute stress reactions that impaired judgment. Louisiana courts reject these claims. The state Supreme Court holds that mitigation evidence, even if credible, does not outweigh the aggravating factors: multiple victims, betrayal of public trust, murder of a fellow officer. Federal habeas proceedings raise procedural due process issues. Frank's attorneys argue prosecutors withheld exculpatory evidence. Federal courts find no Brady violations sufficient to warrant relief. Frank remains at the Louisiana Correctional Institute for Women, 29 years on death row. Louisiana has not executed anyone since 2010, when the state initiated a de facto moratorium due to drug availability issues and legal challenges to its execution protocol. Frank's case demonstrates the intersection of high-profile crimes, police misconduct, and appellate exhaustion. Her sentence stands. Yet, Louisiana's moratorium means execution is not imminent. Victims' families have spoken at parole hearings and public forums. They emphasize the officer's sacrifice and the community's loss. They request that the sentence be carried out. Louisiana clemency is rare. The governor has granted 1 commutation in capital cases since 2000. Texas Execution Database entry, Kimberly McCarthy, executed June 26, 2013. Official record showing McCarthy as the 500th person executed by Texas since reinstatement of the death penalty. Kimberly McCarthy's execution in 2013 marked a grim milestone. She became the 500th person executed by Texas since 1976. Her case involved the 1997 murder of an elderly neighbor in Dallas County. McCarthy, a former occupational therapist, struggled with cocaine addiction. Prosecutors alleged she killed her neighbor during a robbery. Evidence included witness statements, forensic traces, and stolen property recovered from McCarthy's residence. Her trial was marred by racial disparities in jury selection. Out of 64 potential jurors, only 4 were black. Prosecutors used peremptory strikes to remove all but 1. The final jury, 11 white, 1 black. Defense attorneys raised Batson challenges, claims that prosecutors used race-based strikes. Trial courts denied the challenges. The all-white jury convicted McCarthy and imposed death. Appeals centered on jury discrimination. The Texas Court of Criminal Appeals reviewed the Batson claims and found no constitutional violation. Federal courts reached the same conclusion, applying deferential standards to trial court findings. McCarthy's execution was stayed 3 times as courts considered her appeals. Each stay was brief. In June 2013, the U.S. Supreme Court declined to intervene. McCarthy was executed that evening. Her case highlights persistent concerns about racial bias in jury selection. Studies document that black defendants facing white juries receive harsher sentences. McCarthy's jury composition reflected patterns seen across Texas capital cases. Victims' families attended the execution. They expressed relief. Advocates for McCarthy emphasized her addiction history and questioned whether mitigation evidence, minimally presented at trial, might have led to a life sentence had the jury been more diverse. Texas executed 10 women between 1982 and 2013. McCarthy was the last. No woman has been executed in Texas since. Ohio Governor's Commutation Order, Brown, Deborah Denise, January 11, 2018. Executive document reducing sentence from death to life without parole, citing mitigating factors and clemency board recommendation. Deborah Denise Brown's story pivots on clemency. Sentenced to death in Ohio in 1995 for murder during a home invasion, Brown spent 23 years on death row. Her case file documented severe childhood trauma, intellectual disability, borderline functioning, and prolonged physical abuse. Trial counsel presented minimal mitigation. Jurors heard little about Brown's background. The death sentence stood through direct appeal and state post-conviction. In 2017, Brown's attorneys filed a clemency petition with the Ohio Parole Board. The petition included comprehensive psychological evaluations, childhood medical records, and affidavits from family members. Experts testified that Brown's intellectual functioning fell below norms for death-eligible defendants under current Supreme Court standards. The parole board voted 7-2 in favor of commutation. The board's recommendation emphasized documented mitigation never adequately presented at trial. Ohio Governor John Kasich reviewed the recommendation and granted commutation on January 11, 2018. Brown's sentence became life without possibility of parole. She was transferred from death row to general population at the Ohio Reformatory for Women. Commutation is rare. Ohio granted 2 commutations in capital cases between 2000 and 2020, Brown's and 1 other. The process requires board approval and gubernatorial action. Standards include significant new mitigation evidence, procedural errors, or doubts about guilt. Brown's commutation demonstrates clemency's role as a fail-safe. When courts affirm sentences despite compelling mitigation, executive power remains, yet its use is inconsistent. Texas grants clemency in fewer than 1% of cases. Ohio's rate is slightly higher, but still minimal. Victims' families in Brown's case opposed commutation. They felt the original sentence should stand. The governor's order acknowledged their position while concluding that mitigation warranted mercy. Brown remains incarcerated. She will die in prison, but not by execution. Federal habeas petition, Carty v. Davis, filed 5th Circuit, 2022. Legal brief arguing ineffective assistance and unreliable accomplice testimony, citing recent precedents on witness credibility standards. Linda Carty's federal appeals continue. In 2022, her attorneys filed an amended habeas petition in the 5th Circuit Court of Appeals. The petition synthesizes claims rejected at earlier stages and incorporates recent case law on accomplice testimony reliability. Carty's co-defendants received life sentences. Their testimony formed the prosecution's core evidence. Post-trial affidavits reveal inconsistencies. One co-defendant recanted portions of his trial testimony. Another admitted he implicated Carty to secure his plea deal. Federal courts apply strict procedural standards. Claims must have been raised in state court. New evidence must meet stringent criteria. Carty's attorneys argue that the recantations constitute new evidence warranting relief. The 5th Circuit has not yet ruled. Oral arguments have not been scheduled. The case remains in briefing. Carty's situation reflects appellate exhaustion. She has been on death row for 22 years. Her case has been reviewed by Texas state courts, federal district courts, and the Fifth Circuit. Each review affirms the original sentence. International advocacy continues. British diplomats maintain contact with Carty's legal team. Human rights organizations include her case in reports on wrongful convictions and consular violations. Texas maintains its execution schedule. The state executed 4 individuals in 2023. Carty is not on the current execution docket. Her appeals remain active. Victims' families have expressed frustration with prolonged litigation. They view appeals as delaying justice. Advocacy groups counter that thoroughness is essential when a life is at stake. The disparity is clear. Carty's co-defendants, all male, served life sentences. They are now eligible for parole consideration. Carty, alleged to be the mastermind, faces death. Whether that disparity reflects evidence or gender and racial bias remains contested. North Carolina Department of Public Safety Annual Report, 2023. Statistics showing 0 executions since 2006 and current death row population of 136. North Carolina has not executed anyone since 2006. A de facto moratorium exists due to legal challenges regarding execution protocols. The state's death row population remains stable at 136. Carlette Parker and Blanche Taylor Moore are among them. Parker's federal habeas remains pending. Her attorneys filed supplemental briefs in 2021 emphasizing mental health mitigation. Psychiatric experts now conclude Parker's bipolar disorder, untreated at trial, constituted significant impairment. Moore's appeals focus on forensic science. Her attorneys argue that advances in toxicology since 1990 undermine the prosecution's arsenic theories. New studies suggest environmental exposure and post-mortem contamination could explain tissue findings. North Carolina courts have not granted relief. Federal review continues. The state's moratorium affects timing, not outcomes. Sentences stand. Appeals proceed. Executions remain theoretical. Clemency in North Carolina requires gubernatorial action. Governor Roy Cooper has not granted clemency in capital cases. The state's clemency process lacks formal board recommendations. Petitions go directly to the governor. Parker and Moore have not filed clemency petitions. Their attorneys focus on habeas litigation. Clemency typically represents a final option after appeals are exhausted. Victims' families in both cases have spoken publicly. They express frustration with delays. They believe sentences should be carried out or converted to life without parole. The moratorium raises policy questions. If a state maintains death sentences but cannot execute, what purpose does the sentence serve? Does prolonged uncertainty for victims' families and condemned individuals constitute a form of punishment itself? North Carolina legislators periodically introduce bills to reform capital procedures. None have passed. The moratorium continues. Parker and Moore remain on death row, in limbo. Death Penalty Information Center Special Report, 2024, analysis of racial and gender disparities in capital sentencing, with data tables showing women comprise less than 2% of executions nationwide. 7 women, 6 states, decades of litigation. The patterns are clear. Black women facing capital charges typically involve intimate partner violence, co-defendant testimony, or disputed forensic evidence. Mitigation, childhood trauma, mental illness, intellectual disability appears in case files but often goes underweighted at trial. Jury composition matters. Studies show all white juries impose harsher sentences on black defendants. Kimberly McCarthy's jury reflects this disparity. So do jury pools in Erica Shepard's and Linda Carty's cases. Accomplice testimony proves unreliable. Co-defendants who testify receive life sentences. The alleged masterminds, often women, receive death. Linda Carty's case exemplifies this pattern. Her co-defendants walk free on parole. She remains condemned. Clemency disparities compound sentencing disparities. Texas grants clemency in under 1% of capital cases. Ohio's rate is higher. Deborah Denise Brown benefited. Most do not. Moratoriums provide partial relief. North Carolina, Louisiana, and other states maintain death sentences while halting executions. Legal challenges to protocols create indefinite delays. Carlette Parker and Antoinette Frank remain on death row, but execution dates are not set. Federal habeas provides limited relief. Courts apply deferential standards to state court findings. New evidence rarely meets procedural thresholds. Appeals that once took 5 years now take 15 or 20. Victims' families endure prolonged litigation. They attend hearings, file impact statements, request finality. Their pain is real. So is the legal system's obligation to ensure sentences are just. The 7 women on this list represent less than 2% of death sentences nationally. Their cases expose systemic questions. When does mitigation outweigh aggravation? How reliable must accomplice testimony be? What role should clemency play? The answers vary by state, by jury, by judge. Justice depends on geography. Execution database. Composite entry, 2025. Archival record showing execution dates, commutation orders, and pending appeal status for all 7 cases, formatted as official departmental summary. January 2025. The roster updates. Erica Shepard, federal habeas pending. Linda Carty, Fifth Circuit review ongoing. Tiffany Moss, Georgia Supreme Court affirmed, federal habeas filed. Antoinette Frank, Louisiana moratorium in effect, no execution date. Carlette Parker and Blanche Taylor. Moore, North Carolina moratorium, appeals active. Deborah Denise Brown, commuted, life without parole. Kimberly McCarthy, executed 2013. 7 names, 1 executed, 1 commuted. 5 remain under active death sentences. The legal journey reveals systemic truths. Capital punishment in America is not uniform. It is fractured by state borders, prosecutorial discretion, jury composition, and appellate deference. Identical facts yield different outcomes depending on jurisdiction. Mental health mitigation, once ignored, now commands appellate attention. Intellectual disability claims receive heightened scrutiny. Youth sentencing evolves under Supreme Court precedent, yet these developments arrive too late for many. Victims' families seek closure. They deserve it. The legal system promises finality. It delivers delay. Appeals stretch across decades. Execution dates are set, then stayed. Families wait. So do the condemned. Clemency offers a path to mercy. It is rarely taken. Governors face political pressure. Clemency boards meet infrequently. Standards remain opaque. Deborah Denise Brown's commutation stands as an exception, not a rule. The 7 cases on this list are not exceptional because of the crimes. They are exceptional because the defendants are Black women, a demographic rarely sentenced to death. Their cases expose disparities hidden in aggregate data. Execution chambers stand ready, protocols are reviewed, drugs are procured, yet moratoriums and appeals create distance between sentence and enforcement. Justice measured in decades, lives suspended in procedural limbo, victims remembered in court filings. These are the coordinates of America's death penalty system.